Welcome to our video on tips and advice for landlords. Very simply put, the Rental Act states this: it is the right of any property owner to receive a reasonable return on their investment. However, their obligation is to keep the property in a good condition and treat their tenants fairly. The Rental Act also states, as an owner, we may not discriminate. House rules or body corporate rules need to be made clear. The rights and obligations of the parties to the contract must be very clearly and simply put. Defects are to be noted and included in any rental agreement. So what does this mean? The most important thing for any property owner who rents out their property is to check the affordability. Why is this so important? The first thing that is important to obtain is 3 months bank statements. Why is this important? Because the 3 months bank statements will show you the payments and income coming in and out of that client's bank account. The rule of thumb is this: the monthly rental should never exceed 1/3 of the income that comes in. The next step is to obtain a tenant profile network check. Why is this check so important? 1, it establishes identification verification. 2, if there have been any judgments or the client is blacklisted. And 3, which is the most important thing, it tells you the quality of the tenant's payment profile with regards to any previous leases. We also need to make sure that if it is a non-resident, that his work permit exceeds the length or time of the lease agreement. Because remember this, an eviction order, 1, is a very costly expense, and 2, it can take up to 6 months to obtain because it is generally obtained through a high court. What does the Consumer Protection Act mean to you as the landlord and to your tenant? Well, this is what it means. With the Consumer Protection Act, all rental agreements have to be compliant in terms of this Act. So what does it mean to be compliant in terms of the Act? It means the following: the tenant is always seen as the consumer. The tenant as such is allowed at any given time during that lease to give a notice period of 20 days. You, as a landlord, are allowed to charge a penalty if they terminate the lease early. However, you may not profit from any penalties that you charge the tenant for early termination. The renewal or cancellation of the lease agreement must be discussed no less than 40 days prior to the expiry of the lease and no more than 80 days prior to the expiry of this lease. With regards to giving back deposits, if the tenant moves out and the property has been maintained and is in a good condition, the deposit must be returned within a period of 7 days. If there are repairs to the property or damage has been done, the deposit needs to be returned within a period of no later than 14 days. Deposits all have to be paid into interest-bearing accounts, and that interest accrues to the tenant. We then have what we call a rental housing tribunal in each province. What does this rental tribunal mean? The rental tribunal settles disputes between landlords and tenants. The great part about it is that it is free of charge. And any ruling that is made by the rental tribunal holds the same consequence or jurisdiction as a magistrate's court. So the rental tribunal is both there to act in the interests of both the landlord and the tenant. Thank you for watching our video on tips and advice for landlords. I hope it has been of benefit to you and that you have learned something.